Defense made a motion for a mistrial. Prosecutor was up to some fuckery. Potentially damaging evidence, no basis for it. The judge specifically said, do not ask that question. Do not use that as evidence. She walked right down the path and asked the question. It may be over on Tuesday morning. Batman Bruce Wayne bitch snitch. Gerald Brooks, your constitution does not apply to me because I'm a sovereign citizen, a traveler on the land. I'm from the Moorish Empire or whatever, bitch snitch. Because they're so fucking absurd. If you want to be a sovereign citizen, just do yourself a favor first. Go to YouTube here and bitch snitch. Every sovereign citizen that's ever been before. Find me one that won. God dang, you're right. Don't go down this. It's not the path. Don't have time for stupidity. Some clever dick on the internet didn't find the great loophole in all of the world's law. Bitch snitch. God dang, you're right. God dang, you're right. Traveler on the land. God dang, you're right. Moorish Empire. Traveler on the land. Bitch snitch. Moorish Empire. God dang, you're right. Traveler on the land. Bitch snitch. The late evening U.S. people.
I met you at the sideshow at the fair. The sign said, "Turtle woman, please beware." But I went in and I just had to stare. Turtle woman, I love you, I don't care.
Good morning, good afternoon, good evening, everybody, whoever you are, wherever you are, whatever you're doing, and all that other stuff. I'm just glad you are here right now with me, the Lorax, doing our little Loraxian thing with our I was almost late when suddenly that song popped into my head. I thought, oh my God, why haven't I been using that song? So now we'll just have to see if I get copyright claimed for that. That was that was just that was a little clip from a song that was in the great, wonderful Christopher Guest movie Best in Show. Yes, Megan Fox, that is a real song. It's called Turtle Woman. As sung by Christopher Guest. I hope I don't get copyright claim for that one because that was funny. All right. Woo! Well, here we are. It is Monday. How is everybody doing? We had a good, nice, long weekend, a good, relaxing weekend. Things were going well. Things were doing great. I had a good time, a good, relaxing time. Hung out with some people, did some things, laid around the house, was extremely lazy. It was great. We're back at it this week. This is the run-up to St. Patrick's Day coming up on Sunday. And so what we're going to be doing Monday, today, we're going to be doing part 1 of the third hearing. Tomorrow, we're going to be doing part 2 of the third hearing. Wednesday, we'll either do part 4, we'll either like hearing number 4, or we will look at some of her submissions, the 338 pages of evidence that she submitted to the court. Thursday will be our usual O.J. Simpson day. So if you haven't followed the show here for a long time, you don't know. Every Thursday we used to do O.J. Simpson. Then we got interrupted by the Hannah Gutierrez Reed trial, and then the What the Hales thing took my attention. But we're going to slowly ease back into the Thursday O.J. Simpson deal. We're wrapping up with closing arguments in there. So watch some of the greatest lawyers in the prime of their careers giving some amazing closing arguments. Then we're going to go into a new trial about an old guy who offed his siblings and his mother in a allegedly ritualistic witchcraft murder. That's the next old trial we're going to be following. And then Friday is what I like to call F it Friday, where we say F it. We have a great panel of guests. I just grift. It's shots for bucks. That's all it is. And it's fun. It's all in good fun. We get all the grifting out in one day, so I don't have to do it the rest of the month. And because it's St. Patrick's Day, we're doing an all Irish whiskey lineup. We'll be doing some Bushmills 10. Bushmills 10 and some Redbreast 12. Those will be the whiskeys we get into on F Friday. And we've also got a great panel of guests lined up for F Friday so far. The list is Danny on direct, potentially Criminal Sean, that Star Wars girl, Anna, Nick Starro, Lila Hart, great comedian, Runkle of the Bailey, our very own Flux here, Aussie Overlord, Lady Law 579, Steph the Alter Nerd, if you know her, she's going to be popping on by, and Lauren De Laguna, influencer. Our very own Megan Fox has yet to respond to my text message, so we don't know if Megan Fox will be there or not. It's she's only had a week to respond to the text, but she hasn't, so. AMG Law says he's down for it. All righty, we can throw an invite your way too. That's a good deal. All right, so that's sort of what we do. That'll be 7 p.m. 7-ish or 8-ish p.m. on Friday. I haven't decided what the exact start time will be, and we'll just go till your money or my liver gives out. We'll see which one happens first. Megan says, what text? Must have got lost in the mail. Well, F it Friday. You're always invited. And a matter of fact, you're invited right now if you want to join us. If I don't know what you're doing this morning, how much time you've got, but you're always invited, Megan Fox. Hey, Cellulite Podcast. It's Will. Will, what's up? It's been a minute. All right, everybody. We've got a lot of ground to cover. This is a long trial that is reportedly, again, I have yet to see it, but has been reportedly interrupted by a bomb scare. So what could be weirder than any other bomb scare in the middle of a tortoise trial? We'll just have to see. Oh dear. Let's see. I'm copying this here and pasting over yonder. All right. So I'm pretty sure that everybody here is familiar with the What the Hales case. But just in case you're not, we'll give you, oh my Lord, how do you even give a 30-second rundown of this? YouTubers move into a place. A woman moves across the street, allegedly wants to get some money from them to support her, whatever she wants them to support. They say no. Then it turns into a big war between the two of them. There's dueling. I'm gonna turn off my phone here. There's dueling restraining orders. Let's see. There's dueling restraining orders. There's a permanent win in Ohio against the Hales. Well, against Jeremy Hales. There's a temporary one in Florida against Lienette, the tortoise woman who's running her tortoise preserve, where she lives with her former husband, current paramour, in what is essentially a trash heap, living in a shed with apparently no running water because they've built a beautiful outdoor toilet with a beautiful outdoor shower facility, which essentially means a crap bucket in a shed and a hose with a shower head attached to it. Meanwhile, there's broken glass and nails everywhere for their sort of maybe adopted 4-year-old daughter to play in, who allegedly also has a life-threatening metabolic illness. So what a better place to let your daughter play than a trash heap filled with broken glass and nails and tortoises, because they run a tortoise preserve. And I like to read the documents. I like to get into the court documents and see what the allegations are, see what the law that's applied is. But we're not getting there. We're not getting there because the court hasn't done anything substantive yet. We are on hearing number 3, and it's just been an extension. And then it took the judge in hearing 2 about an hour to say, okay, we'll give you an extension. It's been a whole production, so there's not a lot of documents. There's pretty much the submission by Lienette, or Lienette as you're calling her. There's 338 pages of weird stuff that we'll try to look into. I said probably on Wednesday. So that's where we are. We're back for hearing number 3. we're back for hearing number 3, where yet again they're going to attempt to actually get some arguments made on this on this restraining order, this protective order, injunction order, whatever they call it on Friday. My mind has just gone blank. But see, the deal is, after the first hearing, they extended it, but the judge gave a temporary order just before the second hearing, with the idea that the second hearing would be substantive arguments on whether or not to make the temporary order permanent. But everything went to hell. The judge got butthurt because the previous lawyer that was with the Hales apparently didn't hear about the hearing day or whatever. And then the petitioner, Lienette, she essentially accused Hale's lawyer of bribing her. So now he becomes a material witness, which means he can no longer represent the Hales, which means 25 hours before the hearing, he's got to retain new counsel. Then the judge gets all butthurt because there's a new counsel who needs another extension. And he has firmly ensconced himself in the position of Judge Grudge. He's continuing to, he just go back and watch hearing 2. It was absolute nonsense. And, I go through these cycles. It's cyclical. I was curious, then doing the last part of hearing number 1 and the second hearing, I just sort of became angry and enraged, not only at the petitioner, Lienette, but also particularly at the judge. And over the weekend, I think my anger kind of dissipated. There's got to be like, the 5 stages of lawyering, or the 5 stages of LawTube, or something that's kind of akin to the 5 stages of grief, where you kind of go through different cycles. Right now, I'm in the disgust mode. I've just become disgusted with the judge. And I don't know. I don't know if there's going to be any rants tonight. I would guess there's going to be far more of me just going, ugh, than there being any rants or rage at the judge, because I'm just kind of disgusted with him now. It's so utterly uncalled for. Judges shouldn't have grudges like this. I mean, you cannot there's plenty of judges that aren't particularly fond of the lawyers that appear in front of them. And there's lawyers that aren't particularly fond of the judges they have to appear in front of. But there's still the professionalism. There's still the decorum. You still just bite the bullet, suck it up, get through the hearing, and then you go bitch about each other behind closed doors with your friends over a drink or two. But this judge is just openly hostile, openly grudge-bearing, openly. Everybody likes to say that he's prejudiced towards the petitioner, Lienette. I don't think he's prejudiced or biased towards her so much as biased against Jeremy Hales. I mean, it's a fine distinction, but it's time to buckle up and get into it. That's our wrap up. That's our intro. That's our brief little synopsis for those of you that are just joining. And for those of you that are just joining, please, there are 426 of you here on this lovely early morning in the US, afternoon in Europe, and evening here in Asia. For the 431 of you, 155 likes, 300 of you haven't done your job. 300 of you, get down there right now in the next 20 seconds while we wrap up the intro and smash that like button. Let's get us up to 400 likes, just like that. The goal is to get up to 600 and then 1,000. If we can get up to 1,000, that would make me super, super happy. And don't forget to hit that subscribe button. As in this Friday is the F Friday. It's also our 69,000 subscriber celebration. But I think we're going to hit 70,000 before we have the 69,000 celebration. We could get to 70,000 tonight. If all of you that haven't subscribed, just go down there and click it. And those of you that haven't, think you're still subscribed, double check. And with that, getting all your like, subscribe, and doing all the YouTube-y stuff out of the way, let's jump into this trial. Once it starts, it'll take a while to gear up, I hope. I'll put up the poll of the day, the like and subscribe poll of the day, and we'll just read the super chats if and when they come in. As always, the Pig Dog Cam is unlocked at the $100 mark. Let's rock and roll with the What the Hales hearing number 3. Will something substantive happen today? Oh yeah, I forgot. I made this nifty new little trial cam thing there. Boop, there we go. Insert me right into it. I like that. I'm proud of myself for that. I thought that was pretty damn clever of me. All right. Let's see. Volume up. Volume is up. Nope, now volume is up. Now volume's up. Make that a little bit bigger so I can manipulate it easier. And 3, 2, 1.
All right, we are off record. Good morning. I'm Judge DeThomasis. This is case 38-2023.
Yes, we know, Judge.
It's January 4, 2024, 9:11 a.m. We are here subsequent to what I would call the first stage and presentation of the evidentiary support.
Except there was no presentation of evidentiary support at the last hearing.
2023. That proceeding concluded at or about close of business, 5 o'clock that day. We came back on December 6th and continued this matter to today's date. Given the fact that there have been some intervening motions, some of which are within the purview of analysis and review by the Office of the State Attorney, some of which are of necessity within the purview of this court's need to adjudicate so that we can proceed to the remainder of the hearing. And it would be the court's intention to try to resolve all matters here today. Let me just set the record on some of the relevant procedural matters.
All right, set the record straight.
From November 29, which was of record, and 12/6, which was also of record, given the nature of the initial petition. September 7, as I said, 2023, petition for injunction for protection against stalking was filed. The matter was scheduled for hearing without issuance of a temporary injunction initially. The hearing after service was effectuated, was initially set for and did occur on November 29. Those proceedings concluded at or about 5 p.m., the close of business. At that time, the petitioner was towards the tail end, it seemed from the court's perspective, of direct testimony, but had not yet concluded direct testimony. There were 2 additional witnesses potentially for the respondent that were waiting, potentially the respondent himself. And so the court concluded the proceedings with the initial intent to return on December 6th. And there were several intervening things that occurred between the 29th and December 6th that ultimately led to us being here today. Those included respondent's motion to continue on December 1, which was denied.
Yeah, which was denied. But I pause this here just real quick to let you know that we have the new like and subscribe poll up for what it's worth. Hit the like button, hit the subscribe button, take our poll and vote. How would you market the tortoise preserve? If you had to put up a sign to promote the tortoise reserve, what sign would you put up? Tortoise rescue, or tortoise rescue, or tortoise woman, please beware, or don't feed the tortoise woman. Tortoise rescue, tortoise rescue, tortoise woman, please beware, or don't feed the tortoise woman. Sorry, that's as clever a poll as you get today. Deal with it. We'll check what your results are in about an hour.
on December 4, in part, an order directing respondent to present proof of the basis for the continuance that was requested from the November 29 to December 4 date, as the court on November 29 offered to reconvene at 9 a.m. on November 30th. And it was the respondent's counsel.
Oh my God.
Claim and advanced argument that continued it at the time to December 4, or December 6.
Oh my God. Is he still going off about that scheduling for the December? We're already into January. This is January 4th, and he's still bitching and moaning about the first lawyer, Mr. Feather. You're apparently not hearing that the thing was scheduled for December 6th, and that they'd asked for another extension because Mr. Hales had to be in Ohio to deal with some legal issues related to this case. The judge is still butthurt and bringing it up on the record in just a petty, unnecessary, one, waste of frickin' time that's costing the Hales money, and two, just completely unnecessary for any purpose of keeping the record. That's all he talked about for an hour during the second hearing. That was literally the entire hour. The first hour of the hearing was him bitching about this. Oh, what were you doing on November 1st? You could have come here at 9:30. I had to come here to the 6th, and now you want another extension because you had to change lawyers. Okay. I said I wasn't going to get angry and I wasn't going to rant, but here we are. Oh, Lord, have mercy.
December 6th, the court reconvened. At that time, a second respondent motion to continue had been filed. The filing date of that was December 5. The court addressed it on December 6. At that time, there was also an intervening supplemental petition filed by the petitioner on December 4, which resulted in entry of a temporary injunction, as more fully stated of record on December 6.
Ozzy Overlord also here. Good to see you, Ozzy. Welcome. Everybody needs to get on over to Ozzy Overlord and subscribe to him.
And did ultimately grant a continuance of the matter from 12/6 to today's date, January 4.
And don't forget to subscribe to MG Law either, or Megan Fox.
Filed at 3:20 p.m. with the clerk of court, was the first of several petitions by affidavit for alleged violation of the temporary injunction. And it is important to note that literally the same date that we were in court, not only discussing that if the matter was continued pursuant to the respondent's second motion to continue, that the temporary injunction would remain in effect, but additionally, that the court felt a need, and ultimately, and we'll address this because there's a motion that is pending that will address this language.
Good morning, Jules.
An addendum was added to the terms of the standard temporary injunction, which was not opposed at that time by the respondent through counsel. And on that same date, the first of the petition by affidavit alleging a violation, which not only implicates the respondent's actions based on the allegations contained therein, but also implicates counsel for the respondent as being a potential co-defendant of a possible crime of violating the injunction that was entered on that same day, and or as an independent actor committing either a criminal violation of the terms of the injunction and or potentially indirect civil contempt and or criminal contempt.
What you talking about, Willis?
And a review of that affidavit filed on 12/6/23 at 3:20 p.m. with the clerk of court contains such allegations. As a result of that, on that same date, and sure.
These are the allegations against Feather. I believe that he was allegedly bribing her. She said that he offered her money to drop the case, or if she dropped the case, he'd agree to make sure that Hales told people to leave her alone. That's literally what a settlement is. That's literally what a settlement negotiation is. I pay you money or you pay me money, and we just, everybody drops everything. Or, you know, we all just drop our hands and walk away. That's literally what a settlement is. That's literally what it is. The way she words it, she makes it sound like a bribe, but she's literally describing every single settlement negotiation that any lawyer ever has. Okay, well, just everybody drops everything. You know, you tell your client to be a good client. I tell my client to be a good client, and we all walk away. Or I give you money and you walk away. Or you give me money and we all walk away. But I understand that the Hales are making the assertion that their lawyer never contacted her at all. But even if they had, even if what she says is true, it just sounds like a settlement negotiation to me. And I think the judge knows that. But it's idiotic.
Thereafter receipt and the posting of that affidavit, the court entered an order.
What, Ozzy? You're welcome for whatever.
Whatever
I did, you're welcome.
Of possible evidence. And at that time, that order, which is part of the court record, basically directed law enforcement to preserve, to retrieve and to preserve any and all video surveillance of the exterior of the courthouse based on the allegations that were made, as that evidence would certainly be potentially relevant and material.
Oh my God, can we make a bigger mountain out of a smaller molehill?
The respondent's defense to such claim, the respondent's counsel's defense to such claim, the court has not viewed and did not view.
Why not, Judge? Why didn't you renew it? You've had a month to review it. Why haven't you done it, Judge? Explain why you haven't done it.
Location of the allegations and this court's knowledge of the surveillance that's already in play surrounding this courthouse for security purposes, the court entered the order directing preservation of that evidence. To the extent that it helps or doesn't help petitioner and or respondent and or counsel for respondent, or none of the above or some of the above, the court felt it was an obligation to have it preserved to avoid spoliation and unavailability to either party that may be interested. That matter is currently before the Office of the State Attorney, and we're going to get to the same issue on several other matters, and I want to go through them chronologically. But under Florida Statute 784.0487, the Office of the State Attorney has the initial responsibility, and it's kind of a co-responsibility potentially with law enforcement, depending on how the state proceeds, to investigate and determine whether they're going to proceed or not. And following the protocol of that statutory enactment, has the ability then to bring it to the court as a contempt matter and or to prosecute it independently of the court in the criminal courts. So that matter is currently under their purview of responsibility to review. Statutory protocol gives them 30 days. They're within that.
I'm wondering if the judge told them that I specifically told them to work it out, and that we would, if necessary, we would carve out a section of the restraining order that allows them the contact. I wonder if he mentioned that. Cherry Reed, thank you so much for being the newest member of the Clean and Sober crew. Your support is deeply, deeply appreciated. I'm very, very happy you're here, and I hope you stick around for a long time because we love having you here. And Patrick Hemkin says, Jeff, when are you going to get on the bandwagon and interview Jeremy and George? I would love to have them on. It's just the question of how to go about getting in contact with them in a way that they would see it. I'm sure they get 873 million emails to their normal box every day. If there was a way to get in contact with them that I knew of, I would have them on tomorrow. That's how much I would like to have them on. I would have them on tomorrow if possible.
30 days. It hasn't elapsed. And so this court, that's the first of the motions, is not going to review that because it's not ripe for this court to do so at this time. In chronological order, next matter that was filed, and there's going to be several of these filed on the same date, December 18. First would be petitioner's motion to dismiss.
Yay.
That was the word used in the pro se filing.
Thank you, Megan.
Petitioner's motion to dismiss deposition of John Crook. I'll hear from you briefly, but the matter that sets forth in the motion is basically to preclude the respondent and his counsel from taking a deposition of somebody who, from this court's knowledge of having received testimonial evidence on November 29 and having reviewed all the pleas.
Oh, she doesn't want John to have to give a deposition.
Potentially, probably.
Good luck with
Really
that.
high potential of having some measure of relevant and material.
Yeah, he's got to
evidence.
testify.
I had
And
to
it may
jump
not be
over the fence with a
necessarily
bandage all the way up to my
admissible evidence, but it doesn't have to
genitalia.
be, at a deposition discovery stage. It merely needs to be something that could tend to lead to admissible evidence. And certainly the rules of discovery, including but not limited to 1.310, are to be broadly construed in favor of allowing discovery. This court has no intention of precluding any.
God dang, did you hear that? Did you hear that deputy lumbering? I literally thought it was like somebody upstairs, like like clomping around. I'm like, no, this is a very nice condo. I can never hear my neighbors. I was wondering what the hell that was. It's just Deputy Clumpy here. Now, am I correct in my understanding that this is the ex-mayor back here, just behind Lienette? I believe that's the ex-mayor, and the other woman that was the child safety woman or whoever is back there in the back right. But anyway, listen to Officer Clumpy McElephant Feet. Good Lord.
All right, we are off record. Good morning. I'm Judge DeThomasis. This is case 38-2023-DR416. It is January 4, 2024, 9:11 a.m. We are here subsequent to
He's clumping back.
what was what I would call the first stage and presentation of the evidentiary support for the petition that was filed initially on September 7, 2023. That
Great album.
proceeding concluded at or about close of business, 5 o'clock that day. We came back on December 6th and continued this matter to today's date. Given the fact that there have been some intervening motions, some of which are within the purview of analysis and review by the Office of the State Attorney, some of which are of necessity within the purview of this court's need to adjudicate so that we can proceed to the remainder of the hearing. And it would be the court's intention to try to resolve all matters here
Get
today.
on with it.
Yes, get on
with it.
Oh, I am enjoying this scene.
Get on with it.
Record on some of the relevant procedural matters, since this is a continuation from November 29, which was of record, and 12/6, which was also of record, the nature of the initial petition.
Hey, wow. How did we get back to the beginning again?
Get to the same issue on several other matters, and I want to go because it's not.
Oh,
right
I
for this
see.
court.
See, when you watch it on YouTube, a little bit of a boomer moment there, but not a big one. Boomer, because when you hit the arrow key when it's in YouTube, it goes back 5 seconds. When you use this downloaded video in a web browser, it goes back 1 minute. So instead of going back 20 seconds, I went back like the entire time.
To do so at this time.
I was like, my God, he's repeating himself.
In
Sorry.
chronological order, next matter that was filed, and there's going to be several of these filed on the same date,
All right, let's see, where are we?
December 18. First would be petitioner's motion to dismiss.
All right, we can skip ahead.
Investigate
There we
to
go.
prepare a defense to a
There you go.
respondent.
Oh yeah, there goes Officer Clumpy.
John and I are not married. We
I'm
do
sorry?
not, John Cook and I are not married.
Wow. Her voice has changed since hearing number 2. Yeah. Sorry to make you watch even more of hearing number 3 than you wanted to watch. Oh my God. Wow, she's going full on Elaine Bredehoff. Give it a whirl voice there. What on earth? We're not married. We're still living together and knocking boots, but we ain't married. It's like, let's go to Dark Crystal. It's like, Agra. She sounds like Agra. I'm Agra, the tortoise queen.
Okay, that's not a requirement
I
under the
know
law
we do
that you
not
be
live
married.
in the same thing. I have.
Does it matter that you don't live together?
But his paperwork asked for all my journals, my phone.
Separate issue. We're talking about.
That's what they want.
We don't live in the same place. He lives in the shed. I live in the trailer.
John can answer that. So if they're asking John to produce something that he can't produce, it will be up to John Cook to say, I can't produce that because it's not within my control, it's not within my custody, it's not within my possession. And whether that assertion is true and or accurate or not, that's for the respondent and his counsel to then bring it to the court's attention and say, Judge, we think otherwise, or whatever. I don't know how that's going to play out. But what your motion tries to do is an attempt to do is deprive them of the ability to even sit down at the deposition of record in presence of a court reporter under oath and ask those questions.
Yeah, you still need
I presume those types of questions.
I'm not a lawyer. All I know is.
Clearly.
So I'm trying to assist you in understanding
Right.
what is about to report on your motion.
I'm just not letting John come into my house and strip me of all my belongings to give them. I'm not having it.
That's up to you, and it's up to him, and it's up to the respondent and his counsel.
Officer
Seek
McClumpy, will you
remedies
please
if they
translate for
otherwise
us?
need remedy. Let me turn, Mr. Shockett, I don't know if you need to be heard on the court's inclination is to deny the motion as being improper. Discovery is.
It is. Sorry, Lienette. John has to come and
Based
give a
on
deposition.
Interpretation at this stage of the proceedings, I don't intend to deny that.
Thanks, Judge.
That hurts
and
my voice.
And just know that if that would have happened, we would be, all these issues that have come since then, we would have addressed them all at the 2 depots and we'd be fine. So-
Right, which is kind of what I said, and it may have been, I may have said it before, but before we went, but to make it a record, the court believes that there are several motions that are a little potentially illogically inconsistent in that several of these are going to address what could have and should have happened on December 21.
Lynette is,
Project
in and of
4.
herself,
It's now
logically
proceeded to hearing or
inconsistent.
not. So we'll
My
get back
mom
to that.
died.
Okay.
My mom didn't
So,
die.
For the record, petitioner's motion to dismiss depot of John Cook, file 12-18-23 is denied. The next matter is petitioner's motion for legal fees, file 12-18-23.
Your Honor, if I may, so when I can just reschedule the deposition? Then if it's
There you
denied,
go.
it's
Good
just
question.
Asking to dismiss it or prevent it.
So let's get to that
Yeah,
when I
okay.
get to
Do it now, Judge. Why?
your more broadly based motion to compel, file 12-20.
Discovery.
I'll get to that,
okay.
yes. That's,
Right.
that one is number 6 in the
Okay.
chronology.
We'll go in chronological order. That's fine.
Gotcha.
All
So petitioner's motion for legal fees, file 12-18. First, let me say pro se litigants are held to the same standard as a reasonably competent attorney.
I know.
That's just the law of the land. I do read your pro se motion in its broadest sense, and it appears to me you're
It's
seeking
shit.
potentially 2 things. One is representation by counsel, and for which you're not entitled to
Yep.
court appointed representation by counsel. And then the second component, it appears that you're asking for, and it appears to this court, again, from reading your petition, it's almost like a sanction that you're asking the court to sanction Mr. Hales to make him pay for your attorney's fees, which you haven't incurred, but to
Yeah.
provide you with fees that you could incur to hire counsel or retain counsel to represent you.
See, this is why I gave the judge the benefit of the doubt at the first trial, because when you have a pro se or someone who's representing themselves, They, as he said, they are held to the same standard as a reasonably competent lawyer, but the judge, especially in the smaller towns, tend to give more leeway to sort of help them and guide them through the process. What may seem like representing her or favoring her or lawyering on her behalf, most of it was just him trying to get through the damn day, just trying to get through it, get through all the minutia and extract information from her as quickly as possible. But then towards the end, he did get into the advocacy, and then he got butthurt and held a grudge. But the first 45 minutes or so of hearing number one was him, and you can see it even in hearing number two when she's saying that the restraining order in Ohio is no good. And he's saying, well, did you tell the judge that? Yes. Okay, so she didn't believe you. Did you appeal it? He said, I can't appeal it. Well, did you ask to appeal it? No. Okay, so you didn't ask to appeal it. He was just kind of whittling through the info. But here she's like asking for lawyer fees, as he said, that she hasn't incurred yet. Now, if she had a lawyer and if she actually paid the lawyer money, then she may have grounds for asking for lawyer fees, but that would be at the very end. That would be at the very end when we decide if she wins or loses, but not right now under any situation, really. And he's very nicely telling her that. We've already got the dogs chewing on bones over here, so all the crunchy noises that you're hearing, that's strawberry chewing on a bone.
And quite frankly, if
Just
it's to
dismiss
that
it.
end, it's insufficiently pleaded.
Just
And it's,
dismiss
you
it.
submit
It's
no
fine.
authority, legal authority for this court to do so. If there's a sanction, because it implicates, possibly reading it in its broadest sense, that you may be asking to potentially sanction Mr. Hales because of conduct related to the alleged affidavits of violation. And again, that's an issue that hasn't yet been adjudicated by the court. It's something that you can raise at a later date where you're saying fees should be imposed as a sanction. But right now you don't have a right to court counsel.
Right.
There's no legal authority for me to order him to provide you legal counsel, to provide you representation during the litigation.
That's fine, Your Honor.
That
I
would be
now know
similar
how
to-
that works.
Okay.
since he's doing
Stop
it.
interrupting the judge. Good God.
Okay, so are you withdrawing? your
Yes, I'll
request?
just withdraw it.
Okay. All right, so there's no need for the court to rule on that matter. Petition.
All right,
petitioner's
withdrawn.
motion for legal fees filed 12.
Oh, hang on just one quick second here. I got to
Withdrawn by
readjust.
the
Let's
petitioner.
see here.
Just because it happened chronology wise, there is then the
The,
respondent.
the term is chronologically, Judge. Chronologically, not.
Case Nettles versus Hoyos, 138 Southern 3rd, 593, pursuant to 9201.
No, Yoda's right here next to me, too.
The court's familiar with the case based on what I previously just kind of said, and I'm going to say when we get to what is numbered 6 in the chronology of events, motion to compel discovery, I'll more broadly address this, but the court has no intention of denying discovery. And I quite frankly didn't interpret. I'm not questioning your broad interpretation of what the petitioner may be trying to accomplish, but I don't think it's as broad or as comprehensive as her asking the court to deny you and your client any and all discovery. It was just really, as I looked at it, as to her ability to give a depo or not on a 1221 and her willingness to have Mr. Cook. We've already addressed that. So I'll get back to that, but the court is taking judicial notice. The court's certainly aware of the case precedent. Next number in chronology is petitioner's motion to continue depo.
Thanks, King Bob.
And so I guess let's get to this issue of this logical inconsistency of whether it's now moot and respondent is ready to proceed without the deposition. Here's the thing, that motion was filed on December 18, asking to continue the deposition scheduled for 12/21. It's not like the court gets a bulletin 24/7 that says, hey, a motion's filed in one of your whatever pending hundreds, if not thousands of cases that are pending. And nobody requested hearing. It's not an emergency. It wasn't urgent. It wasn't presented that way. And so
Now, Judge, if I recall correctly, you were crushing his new lawyer for having the gall, the audacity to take on a case that he wasn't prepared for just 25 hours before the hearing. And that boy, that's just asking for trouble. That's just asking for misrepresentation, because he could be negatively impacted by having a lawyer who's just not ready to go to. I sure hope you told him that you're not ready to go if the judge says go. Judge just said he's had a month. He's had a month to consider this, but he didn't. Nobody told me. Nobody gave me this. Judge, why didn't you stay on top of your calendar? Judge, huh? Why don't you look at these things that were filed over a month ago? It's December 18th. Okay, this was January. So yeah, 3 weeks before this, I guess. Why don't you stay on top of your submissions, Judge, for all of your, if you have too many cases, Judge, perhaps you should tell all of the litigants before you that they may be adversely affected by your inability to stay on top of your calendar. Perhaps we should be assigned to a judge that has a better ability to be ready to handle these things. Perhaps we should do that, Judge. Did you do that, Judge? Did you? Did you? I hope you did. Doofus.
Is it moot because other arrangements were made? I guess not, because of what you said just a moment ago. I didn't know that until a moment ago. And if there's an intent,
he doesn't have a robe, it doesn't apply. Exactly. See, his name's not on the door.
Which would include
the lawyer's name's not on the door.
Mr. Cook, that the court has already ruled on that motion, and the court can certainly and would direct Ms. Preston to likewise provide a deposition within reasonable. And that reasonable has now been reevaluated as a shorter time frame.
Judge, she does fuck all during the day. If you just tell her what day she has to give that deposition, what day John has to give his, what day she has to give hers. It's not like they're busy doing anything else other than torturing tortoises and possibly small children.
Include, because of the time and space continuum we live in, that the evidentiary hearing not proceed today.
Unfortunately, that was not our intent.
I'm not saying that it was, but it could be the conclusion of providing you the relief that you're entitled to, and the court's inclined to grant. And so let me go back to the petitioner. Ms. Preston, it's your motion to continue that no hearing was ever requested for. And so it appears unilaterally, maybe for good reason, but without court approval, you didn't appear for or attend your deposition.
Oof. Yeah.
And
arrest her.
I don't have the complete record from your motion or from the record. I don't know if you had been served subpoena
For my for
your
deposition on me?
deposition.
No,
Liar.
I'm not only John Cook. And the day that they wanted John Cook, he could not come, and I've already provided that to the court.
No, that's John Cook's idea to
Let's
provide,
move away
not
from
yours.
John Cook.
Exactly.
You served with a subpoena
No.
for the deposition.
I've never been served about me doing the deposition.
Oh, I hope to God somebody has a receipt for service. So there's a process server somewhere that if it was served, has some sort of process report, a receipt of service, something out there saying, yes, it was served this date, this time, in this manner. Oh, I hope that's out there.
Your Honor, she's a party.
Right.
Yeah.
I just want to know in terms of
It said John Cook. It did not
whether
say me.
there's sanctions or not. And so arrangement, how did the December 21 date come to pass?
It said John Cook, subpoena for John Cook. That's the only paperwork we got.
He got a subpoena, correct?
Right.
How were you ever aware that you were also supposed to give a depo on 12/21?
No,
You're saying you weren't aware of it?
no,
Then how do you file a motion to continue your depo for 12/21?
I didn't. John's for
What?
John, because if John is being deposed, then
What in the name of shit are they talking about? The judge is the judge is here. The judge is trying to make sense of this too. There's the subpoena for John Cook to give his deposition. There's her subpoena for giving a deposition. Apparently they're supposed to take place on the same date or thereabouts. I don't know, but she says I didn't get served. But then she also filed a motion to continue that to reschedule her deposition. So if she didn't get served, how the hell did she know that she had a deposition on that day? If she didn't get served, how could she possibly know this? Now she's saying that she filed paperwork for John. You can't do that. What in the hell is going on here? Judge, for the love of God, if you do one thing somehow in the next couple of hours, just make it make sense.
I have the right to be there to question him, right?
What?
Correct.
My mother was dying in Naples, and I was in Naples, Florida, with my mother in the nursing home,
All right.
Crashed
Hang on.
on-
Let's back up a second here.
and I sent that to
Filed
the
with
Okay. Wow, we've got the mom hat trick here, people. We've got the mom hat trick. During her first deposition, within the space of 3 seconds, she contradicted herself when she said, "My mother died." Your mother died? No, my mother's not dead. Now she's got her mother's dying. So we've got the hat trick, the Lienette hat trick, the tortoise queen hat trick. Mom dead, mom dying, mom not dead. So there we go.
clerk of court on December 18 at 1:13 p.m. I'm looking at it. Petitioner's motion to continue deposition asked for by Mr. Hale's counsel. And it
because
says we, I don't know who we is because it's really just about you. I presume it's Mr. Cook, but it's really just about you. Can't make it that day due to doctor's appointments. And then it says I, which is accurate and more articulate, appropriate. I can't make it December 21 because I have a doctor's appointment I can't change.
She clearly knows
So if
she
it
has a
can't be
deposition on the
dismissed, it
21st.
needs to be rescheduled. And so I guess
I
when
was
I
not,
read that, that tells me you knew you were
Yeah.
supposed to, maybe by agreement, maybe by notice, maybe by subpoena. You're saying not by subpoena. That's fine. You're party. I hear that. So by somehow to notice, that on
John
December
Cook.
21, you were going to give a depo.
No, John, it only said John Cook. The only paper we got was for John Cook to
Then
give a
why,
deposition. I've never seen anything about me giving one.
then why are you
So
talking
what you're
about you
saying
giving
is
it?
on December 21,
We
your
left
motion,
for-
wait, hang on. This motion then, because I'm trying to
Okay.
interpret broadly, but
Right.
I've got to, if a lawyer filed this, I'd be reading it the same way, which is you're seeking to get out of your deposition.
No, I never been, I didn't know I had to take one. John Cook had to take a deposition.
So what this motion is basically saying, we need to be absolved of responsibility to appear, me as the party who gets to also question Mr. Cook.
Yes, yes,
Mr. Cook for other reasons, which I
Yes.
denied.
yes.
So
And he
okay.
called me
I-
while I was on the road. He said, well, you can't come. And I said, no, I can't come. I had a doctor's appointment, but now I'm sorry, but I am on the road right now to Naples, Florida. My mother was put on life support and I had to rush there to say goodbye to my mom.
Oh my
And
God.
I
Is
sent
her mother
them,
alive or dead?
I posted something with the clerk of court telling you where I was.
Okay.
And my sister provided a note saying where I
The court
was.
interpreted that as those are all the reasons why you couldn't give your depo, which
Now look, Judge, you hauled Jeremy's ass over the fire for so long during hearing number 2 because you were butthurt over the fact that you and his counsel had a little bit of miscommunication where he had a flight scheduled for the next day so that he could be in Ohio the following day for court work, where you were just hell bent to hold him to the standard that he said to you he had to be in court the following day, not get on an airplane. You asked him to submit evidence that he was supposed to be there, evidence that he went there, evidence that he actually attended the hearing. And here she's going, I just phoned in something and said I got to go. My mother's dying, so I can't go to this and I can't question that. I can't because I got to go put my why aren't you yelling at her, making her give you proof that her mother is in a hospital in Florida, that her mother was in fact put on life support, that she actually went to Naples? Why aren't you putting her to the same proof that you're putting Hales to, when I think her proof, this is her situation. She should be required to prove that this, my mother is dying every 5 seconds, or in some cases may already actually be dead. This excuse has been brought up so damn many times that this is the one you need to grill on. You need to make her, you prove that or hold her in contempt. Prove that she was on life support, prove that she went there, prove that this was all cleared to the court, or hold her in contempt. Do your judge Grudge.
Which is different than you couldn't be there for Mr. Cook's depot, for which you had a right to be there and to question.
Right.
That being said, hang on, Mr. Shockett, what would indicate, if anything, that Ms. Preston was also to give a deposition herself that day?
Well, thanks, Judge. First of all, two things. There's two separate motions. One's directed to John Cook separately, saying no deposition, no rescheduling.
Correct.
Nothing. This one says rescheduling, it's hers. I did speak with her. In her written motion, I said, okay, what time's your appointment? Maybe we can do it afterwards. Maybe
You
we can
did
do it
not
next
say
day.
that.
She
You
said-
did not
Shut
say
up!
that.
Chance to speak. We can't interrupt each other.
Sorry.
In part, number one, because we have to control the court.
All right, that's getting on my nerves. But we do have the very first super chat of the evening. Thank you so much, Stingy, for breaking the seal on these super chats, putting us only $98 away from unleashing the pig dog cam. Lienette is just
Lienette is just another
species of Skeksis.
Skeksis.
Dark Crystal's one of my favorite shows. She's somewhere between Agra and Skeksis on the vocal range.
Proceedings
sorry.
professionally here and give people due deference. Number two should be number one, due process requires I get everybody an opportunity to be heard. And number three, we're keeping a record and we don't want to talk over each other.
Okay.
Thanks.
Thank you so much, Stingy, for
She
the
said
super
that.
chat.
I said, okay, maybe we can do it the next day. She says, to these effect, I can't give you any other dates. 10 minutes after I filed the motion, I found out my mother's deathly ill, to these words, and I have to go out of town. I don't want to be coming back. I may not even be back for the January 4th.
What? Yeah.
That's when I filed the motion.
No.
I included that language in the motion.
Your motion being the motion to compel.
Yes. I said, well, you're just
Yeah.
fine. Tell me you can't even get here.
Which is why you interpreted her as attempting to deny you, your client, all discovery.
Oh,
Yes.
Yeah. That's all we need here, just 1 day of deposition.
What was your intent if you accepted the course of that conversation? Okay, maybe we can do it later today after you get to see, you going to do it by Zoom or something?
Yeah, it was set for Zoom, Judge, making it real easy.
Okay.
And I just said, fine, what time, if it was the morning, maybe when you get out, give me a call, we'll get to the next day. I was immediately told 10 minutes after, there's something you don't know, my mother's dying. And I can't agree to any other days.
Agreed to
Therefore,
any
the
other
motion.
days.
So, Ms. Preston, with regards to, do you corroborate that
That
at least that
conversation never
conversation
happened.
was Mr.
Never
Shockett
happened.
trying to get your deposition at some point?
No, he never said my deposition at all. Not one word about me giving a deposition. The phone call was this.
Just so that we're clear,
Just so that we're clear, I don't know any of these people personally. I know nothing about them other than what I've seen here, but I'm gonna tend to believe Jeremy Hales' lawyer. I find him to be a little more credible than the Turtle Queen, than the Tortoise Whisperer. I'm gonna believe the lawyer over her any day of the week on this issue. Judge, you know you should too. So let's see what happens. But before we do, Alan69, thank you so much, Alan69. Let's get Jeff to 70,000. Don't forget to subscribe. Oh, if you got me to 70,000, that'd be awesome. And please, please, please don't forget to subscribe. Chris Rowland with the shit emoji. Thank you so much, Chris. Yeah, it kind of sums this whole thing up. We're already 25 minutes into this hearing, and very little has happened. She withdrew a motion, and the judge dismissed. He dismissed a motion that clearly had no. I mean, literally, if there was some number that was possibly less than 0 chance of something happening, that's how much chance that motion she made to get to clear John from any responsibility for attending a deposition would have. Ugh. Thank you so much, Alan69 and Chris with the super sticker. I wish the super stickers showed up on here because it's just the shit emoji. Thank you, Chris, for the support.
Let's say, and I'm not making this finding here, but let's say you were not led to believe on December 21, prior to December 21, that you were going to give your depo, and that it was only limited to your belief.
She's only
on the
mostly
21
dead.
Cook was
Her mom's not totally dead. She's just mostly
you were gonna
dead.
attend as a party. So let's assume that premise.
Okay, truth.
Are you also saying, though, that when 12/21 came around and this conversation took place and you were on your way, maybe for good reason, I'm not making that finding, but let's say that it was for purposes of this premise, good reason you're somewhere else, Mr. Shockett's saying, okay, I'll accommodate, we'll do it. And part of it, what he's saying is, although we'd like to do it today, we want to do it today, and we can make it happen today because it's by Zoom and you can be there. When you're concluded, we'll get started. Or give me another date between now and when we come back, because we've got a trial on January 4th.
I'm under oath, under God, that conversation never happened.
Okay.
Here's the conversation.
So hang on.
Now's when we need her like army of flying monkeys to come in, and like the gorilla guards to be like, and all the palace people coming in and singing, she's not only merely dead, she's really most sincerely dead. Ding dong, the witch is dead.
Tell you word for word, because that's the kind of brain I have. Miss Preston.
Oh my Christ in heaven above. Did she just tell the judge that she has a flippin' photographic memory? Yeah, even Yoda thinks that's a bunch of crap. Yoda, you tell him. I know, Yoda, she just told the judge that. She just told the judge she has a photographic memory. I remember exact words. I got a memory like that. I know it's shit, Yoda. You know it's shit too. All right, let's let it go. Oh my Lord. This woman has a photographic memory? Oh no. Kill me, please.
Trial on January 4th.
I'm under oath, under God, that conversation never happened.
Okay.
Here's the conversation.
So hang on.
I'll tell you word for word, because that's the kind of brain I have.
Oh no.
Miss Preston.
No, you don't.
Can you be at the deposition on the 21st? He said, it says here that you have a doctor's appointment. I said, at first I had a doctor's appointment, sir, but right now I am on my way to Naples. My mother has been resuscitated twice now. I've got to get there to say goodbye to my mom. He said, so are you going to be at the hearing? I said, I don't know what's happening right now. And he said, okay, give me a minute. And he hung up the phone. That's the conversation. That was it. And he never called me back.
Okay.
Never called me back.
Let me ask you this. Do you understand that it is your obligation to provide a deposition if they want to conduct their discovery by virtue of your deposition in part?
If that's what they need to do, then that's what they need to do. I called the clerk of court 5 seconds after I talked to him, explained to the court what I was doing, what was happening. They told me, they said, they called me Michelle. They said, Michelle, then get something from where you are at the hospital and showing that your mother was dying and that you had to be there. And so the minute I got back, I provided the court with an email from my sister saying when I was there and when I left.
No. See, kudos to the court. Kudos to the court for making her submit something or submitting something to the court to allegedly prove that her mother was on life support. She just said that what she provided to the court was an email saying from her sister saying the time she got there and the time she left. Not that her mother was on life support and this was when she got there. It's just, oh, my sister paid me a visit and she got here this time and left this time. There's nothing about that unless she's going to add it here next. But King Bob with a $4 super sticker. It looks like a cup full of, I'll just call it wine because I like alcohol being consumed. Thank you so much, King Bob, for the super sticker. And Irish Rover. What's up, Irish Rover? Speaking of Irish Rover, don't forget to join us Friday for F It Friday, the panel show where we bring in a whole panel of people and we consume Redbreast 12 and Bushmills 10 for our St. Patrick's Day celebration, along with the 69,000 subscriber celebration. We're gonna have a big St. Patrick 69 party. So join us for that. The Irish Rover, my mother died, but she got better. Is now on life support. That seems to be her argument.
She died. Well, she died. She got better.
Now she's on life support. Yeah. I mean, if that's your mother, oh my God, I'm sorry. I know that can happen. But if it's her, I seriously hope to God that's not talking about your own mother, because then I'd feel really bad. But for her, I ain't buying it.
So what's not necessarily before the court is to sanction you for non-appearance on 12/21.
Sanctions.
What is relevant and is before the court is compelling you to give your deposition. And I got to just say,
Can they serve me with one?
having practiced, including on the bench and as a lawyer, 40 years in and out of courts almost on a daily basis for 40 years, I'd be hard pressed to conclude, although strategically sometimes this happens, but be hard pressed to conclude that the respondent in a case of this magnitude, of this nature, based on the totality of these circumstances, would not, as part of their discovery, also maybe want to take a deposition of the petitioner who brought the cause of action.
Can you
It would make
please
no logical sense.
ask them
That would not come up in conversation.
They have a
Right.
process server do it every time. So provide me with where the process server served me those papers, because I've never been.
Do it.
served
For
for
the love of
deposition.
God, do it.
Counsel's not saying that you were served. You're a party. You're being treated in a different protocol.
Okay, so he's saying you're just
saying that You
notified.
didn't even know you were going to give a depo.
Yeah.
No,
Do you understand it's your obligation to provide a depo? Let's get to the heart of
Yeah,
it.
there
that's
you go.
fine. If that's what the court is saying I have to do, then fine.
The court is saying that.
Okay.
So,
So when?
But I was
Shaka,
not
I
served.
intend to address the rest of these matters, but is it your client's intent, or you're on his behalf to pursue what I'm calling the strategic decision, which seems obvious, to take the deposition of the petitioner?
Absolutely, Judge.
Okay.
Oh hell yeah, they're gonna
We're gonna
depot.
come
They're
back
gonna
to that.
depot
So
her
you're-
again. It was too much fun the
So
first
the
time.
petitioner's motion to continue the depo, to the extent that it related to continue it because you, the petitioner, couldn't be there for Mr. Cook's deposition,
Right.
as much as the court doesn't really interpret the written
Oh,
motion
no.
that way, given that explanation, it's denied as moot because of the ruling already on the John Cook deposition, which is a necessity. And it's resolved that way. To the extent that it's not you giving a depo on that day because you couldn't give a depo on that day, given the court's conclusion and your
Just hold her in a little bit of
acceptance
contempt,
of the
please.
responsibility to provide the deposition if the respondent, as he's through his counsel has suggested he intends to do, we're going to get to, when we get to this next motion, two down the road, of coming up with a compliance date for you to provide that deposition. All right, so it's going to require the deposition, and it's going to require it within a pretty short time frame. But
Good.
It is
I hope it's been done.
unnecessarily, because it could have been avoided, likely to cause a delay. in
Oh,
these
and
proceedings.
another delay, another extension. We, of course, we knew this happened because we're already on hearing number 5. We see now. We know this is going to end in a continuance. There's still almost 2 hours of hearing left, maybe a little more, maybe 3 hours, somewhere around there, of this hearing left. What the hell are they going to talk about for the next 2.5, 3 hours? I'm scared. I'm really scared. Oh, I tried so hard. I'm a weak-willed person at heart. I can't not consume an adult beverage whilst watching this. I apologize for my failings and my weaknesses as a human being, but sometimes you just need it. And this is a Port Charlotte 10-year heavily peated whiskey from Bruichladdich in Scotland, from the Port Charlotte area. Oh my God, what a great whiskey that is. It'll help me get through the hearing. And while we're here, it's the 1 hour is the midterm grift. I talked about Etched Friday coming up. That'll be Friday evening around 7 or 8 p.m. Eastern time. I'll lock down the time probably tomorrow. Don't miss that. We talked about that. We've got 960 of you here right now. 498 likes. That's 499 likes. 462 of you haven't done your job. 462 of you, get down there right now and please smash that like button. Get us up to at least 700. YouTube likes 600. That's a good place to launch them where they go, oh, look, there's 600 people that have liked this and 1,000 that are watching. This must be really cool. Everybody come and watch it. Then we can grow and we can all be happy. If you haven't hit the subscribe button, we're inching our way towards 70,000 subscribers. And if we can get to 70,000 subscribers by the end of this week, that would be so freaking awesome. That would put me 30 away from my little plaque and I can feel all special, warm and fuzzy inside. So hit that like and hit the subscribe button, guys. Join us for the rest of the week. It'll be this OJ and Etched Friday. Thank you so much. Let's jump right back into this. No reason to make that any longer. I don't want to go Judge DeThomasis and delay it too long. So let's just go.
And I understand, and we're going to get to it too, but I want to take things in order here. That if there's a delay and there's an extension of the temporary terms of the injunction, that the language of the terms of the temporary injunction are all subject to a separate motion to reconsider or modify the language. I'm going to get to that.
Okay.
So,
but can we just put a pin on that just for a second? Because it is important. You just said something, Judge. The temporary injunction was continued to today, and that was the rush to take deposition testimony, was because we wanted the hearing today.
Oh, this is interesting.
The delay was caused by the petitioner.
This is a very interesting argument.
It effectively prevented the test.
Okay, I like this argument. She was given a temporary order until today. Today was supposed to be the day of the hearing, where everybody puts their evidence on the table and he decides whether it was completely unfounded and should be dismissed, and he's free to get rid of the temporary restraining order thing, and or whether there is sufficient evidence and it should be made a permanent order. They're supposed to do this today. Because of her, it couldn't be done today. So the deadline for the temporary order to expire is this day. But it's not going to be this day. They're not going to make the final decision this day because of her. So he's going to argue, therefore, that her application and the order should be dismissed. And, she can refile it if she wants, but it should be dismissed because it's delayed due to her own damn fault. Of course, I have a pretty sneaky suspicion how the judge is going to rule on that.
Any deposition discovery. So the petitioner has created her own delay.
Yes.
I'm going to ask that the injunction, aside from being modified, the temporary injunction, because of this delay, be lifted until we come back. And I'm okay with a real tight schedule here.
There you go.
But I think that this temporary injunction, we wanted the hearing, Judge. We wanted to be heard. We wanted the final hearing, but we also needed her testimony, especially with all these new testimony.
The we may be you and Mr. Hales. I'm not questioning that.
Sorry.
Of course.
But the we on November 29, according to Mr. Hales' prior counsel, was anything but.
Judge,
what was represented at that time is we could resolve this, Judge, in a couple of minutes, and it was this court.
Oh, Christ, he's going back to that.
Words of the transcript would reflect this. It would be an abomination of due process for this court to railroad this case through in the next 15 minutes, and I couldn't see in all my years of litigation that anyone could possibly cross-examine 2 hours of direct testimony and present 2 additional witnesses, give closing.
There wasn't 2 hours of her stupid direct testimony. There was 2 hours of your damn rambling. He said he could wrap up the cross-examination of her in 15 minutes, and it might be clarified, so they might not even need to call the other witnesses. In any event, they're willing to stay as long as it takes. That's what was said, Judge. Perhaps you should ask her in her photographic memory what was said. She remembers everything because that's the way her brain works. Ask her exactly what was said. Judge, let it flip and go. Let it go, bruh. Why are you holding a grudge like this?
Argument
in 5 minutes.
Conclude in 5 minutes.
Yeah.
It was not going to happen.
That wasn't me. That wasn't me.
Wasn't me.
And also, all these other, filings have occurred. So
it's that shaggy defense.
All these things to get all teed up for today. So this is the delay caused, and now we have prejudice on this side because of that. So it asked that the injunction be lifted
So
even
that's
for a
gotta be
temporary basis.
balanced. We're going to get to that.
Okay,
But
I
that's
just
going to
wanted
be
to-
balanced against the potential
Photographic, not audiographic.
risk, if you will.
She remembers everything
associated
exactly.
With there not being.
That's
the
how her brain
protection in
works.
Place that initially on September 7th was denied. There was no temporary. It was a hearing only. There was a subsequent, and I'll get to the date the court record will reflect, a second, if you will, or a first supplement that denied the relief of a temporary injunction and nonetheless remained for hearing. And then I think it was the second supplement on or about 12/1 or 4. I mentioned it previously in the record, it will accurately reflect that it was that supplemental petition that led to the temporary relief that we're now dealing with, although the court added the addendum based on. So we're going to come back to that. It sounds like there's going to be necessarily a request to continue this.
Yes.
But what that looks like, we're going to get to.
And also, Judge, thank you correctly, in that final 12-4, the third time around, I think you said, considering the previous filings, really, the cumulative effect of them. I think it says something like that, considering the previous filings and the one on the
Yeah,
floor.
well, that's this court's view of a supplement is a supplement to
Supplement.
the prior as opposed to a new cause of action.
Right.
Sure.
And so, yeah. So the next matter chronologically that was filed on December 18, also a petitioner motion, was petitioner's motion for clarification. That's what it's styled.
Yeah, I'd like to make a motion for clarification myself. What the hell is going on in this case, Judge? How about we clarify that? That's my motion for a clarification. I would like you to clarify exactly what the hell is going on. What I do know is going on is Tammy F has dropped a super sticker. It says, hey, you. Well, hey, you, Tammy F. Good to see you here. Been there, done that. I'm not dead yet.
I'm not dead yet. Feel fine. Feel happy.
Yeah. Thank you, been there, done that. And Tracy Fagan. Judge wants to make new law. He wants to do something. I mean, that could be it. He wants to go down for being famous. He's well on his way to becoming infamous. Sorry. If any of you haven't seen The Three Amigos, you need to see The Three Amigos. It's infamous. It's more than famous. It's infamous. And Secret Squirrel said, I'm from Scotland and I can confirm our whiskeys are phenomenal. And Bruichladdich is my favorite distillery because they're not only phenomenal, they're phenomenal. That's a Pete joke if you get it. Right. Phenols. Anyway. And Nick Starrow's trial watch. Thank you, Nick Starrow. I thought she had a medical condition that made her not knowing time and dates. Yeah, she did mention that in her deposition, didn't she? Yeah. She I have no concept of time or dates. Now she has the photognomonic memory, right? That's how she works. She forgot that. She forgot she has memory problems. I guess. And Jill M's, we'll get you. Thank you, Nick, by the way. Thank you so much. Jill M's, thank you. What do you get when you cross a turtle and a porcupine? A slow poke. Lol. I'll reserve the lol for later. I'll take the lol under advisement, but thank you, Jill M, for the super chat. Let's find out the next item of business. What needs to be clarified other than everything? Megan and I were talking about this. Is both of my favorite movies the other day. It's more than famous. It's infamous.
As the court's view of that, in a light most favorable to the pleader, is that what you're seeking is an advisory opinion. Effectively, what you're saying,
Yes.
if, which is a hypothetical premise, if I run for office, would I lose the protection I might otherwise have from the injunction?
Oh, God.
That's asking the court for an advisory opinion.
It's her application
While
for
the court does
clarification.
a lot of things and has a lot of power to do a lot of things. The court does not give
I'm not a
advice
lawyer.
or advisory opinions.
I'm not a lawyer.
Yes,
Okay,
we're well
understood.
aware you're not a lawyer.
And so, to the extent that you're seeking an advisory opinion, there is no justiciable issue to be adjudicated by the court. There is no case in controversy
Right.
requiring adjudication by the court. That motion is denied. The next motion chronologically, although it occurred filing on the same date, 12/18, but chronologically for this court to address here today, is the petitioner's, it's a motion for clarification regarding removal of all prior videos.
Excuse effing me, what? She wants the court to order Jeremy Hales to take down all of his YouTube videos? Get the F out of here. Come on. I know you're not a lawyer because you keep saying it every 3 seconds when the judge shoots down your stupid petitions, but come on, you know this ain't gonna happen. You know the judge isn't gonna order him to take down all the videos. Come on. Don't be
ridiculous. Also a
ridiculous.
question contained within that, which is a two-part question. One, did the respondent give up all his firearms? And number two,
none of your business. That's between him and the court.
Well, I guess it's a one-part question. You wanted you wanted proof of compliance with that. I believe the court record does reflect that compliance. That's a law enforcement issue.
Right.
Failure to turn over firearms pursuant to court order is a crime. And that's an issue for law enforcement to decide. So to the extent that you're asking the court to do or not do something about that, or to the extent that it might be an allegation that there's some sort of alleged violation of the terms of that, that's either the state attorney and or law enforcement's purview. But to the extent that you're asking the court to clarify, which is a lot different than modify, because I'm not going to modify because that changes the rights of the parties. But if you're asking me to clarify whether the prior order and injunction, even with the addendum, require Mr. Hales to remove any prior videos up until the date of that ruling on December 6th and that addendum, the answer is no. And the reason the answer is no, it did not require him to do that is because at the stage of the proceedings of November 29 at or about 4:45 to 4:50 or whatever, when the court said, obviously this is going to need to be continued, we're not done with this hearing, I had not adjudicated on the merits your claims in direct testimony, which were not subject to cross-examination. Mr. Hales didn't have an opportunity to present evidence, which could include his own testimony that might contradict what was testified to. And so I couldn't adjudicate that the behavior up until that point was in fact under the statutory provisions, quote, cyber stalking, unquote. Okay. Because the court, or as a result of the court being required as a matter of law to review your petition, your supplemental petition in a light most favorable to you and accept what's being pled as true and does it entitle to relief, to the relief of a temporary injunction, that's wholly different than the court adjudicating on its merits in a contested full due process hearing that in fact what happened was the following, and therefore as a sanction.
Am I this annoying because I talk with my hands a lot? Am I as annoying as this judge when I talk with my hands? Because this judge is starting to annoy me. It's, good Lord.
The court's going to direct removal if that is even going to be considered. But maybe a convoluted explanation, but this court did not.
Well, thank you, the people that are saying no, I'm not that annoying.
Direct him to remove anything prior.
Right.
It implicates constitutional free speech. It implicates what would in effect be a punishment or a sanction that wasn't necessary from this court's view as far as temporary relief based on the court having to accept what was pleaded as true.
I just simply didn't
And we're in the middle, we're
know if
literally
that's
in the
what
middle
it
of a trial. This court's not going to start imposing sanctions in the middle of a trial. So
see, the judge has moments of lucidity. He's clear and he makes sense sometimes.
That's fine.
So good for him.
Require him to do so. And so to that extent, the motion is, as this record would reflect, ruled upon by making it clear to you what was in the record. The next matter then up is the respondent's motion to compel discovery, file 1220.
All right, here we go. Compel
It's a reference to
discovery.
deposition.
Make them get their depositions
In large part.
Good.
And we've already addressed a large portion of this. But basically, as this court said, this court has no intention to deny either party the discovery rights that they're entitled to as a matter of law, or to curtail discovery. It would be this court's intention, however, especially now more than even so at the outset, which is to tailor a time frame of discovery. So I can tell you straight out, if there's no temporary relief in place, the court might lean towards saying, let's move discovery a little bit quicker because there's no protection in place. If there is protection in place, the court's going to try to move discovery sooner in a shorter time frame because there's ramifications to even a temporary order, even though it has not yet been adjudicated. So the bottom line is, regardless of what the temporary status is of the case as it's waiting to be litigated, this court
So he's just spent 2 minutes saying we're going to try to move this along as quickly as possible.
Respondents' needs and the court's needs to get the litigation moving in a timely fashion without depriving anyone of their rights to full discovery.
How about you shut up and move it along?
More relevant and more prevalent that the court do so because we lost from 1221 to 1-4. And so I guess, Mr. Shockett, let me hear from you first with regards to, so the relief that you're seeking to compel discovery is going to be granted, but to the extent that is granted, give me a sense of what you're proposing of where we go. And
Depose her, depose him.
It's separate and apart from whether the temporary relief of the temporary injunction remains in effect, and if it remains in effect, whether it's modified or not. So we're going to get to that, but just on the matter of calendaring of discovery, the court in effect is going to compel the depositions of Crook and Preston.
Good. Compel them, force them to get their ass there and to both of them be deposed, and don't let him do it by Zoom. Because she can behave like a jackass, like she did in the last deposition. Bring them in somewhere, to the court, to the lawyer's office, to a neutral location. Make sure they go somewhere where they can't walk out of the room, where they're forced to be there face to face. They can't, go off on Zoom like she did during her ridiculous deposition and scream at the child, scream at John through the window, and claim that she can't hear and her phone breaks down and she just got a crappy tablet. And bring them face to face, put them in a room, turn the camera on, hit the record, and make it like it's meant to be. Make it a real deposition. We're done with his online stuff. And Vince Clortho with the $2 says, who is the person behind Lienette? That is the former mayor of Otter Creek. I'm taking it his name is Russ because everybody's calling him Russ the Sus. So yeah, that's the former mayor sitting back there. And he apparently is going to try to testify on behalf of Turtle Woman, on the Tortoise Queen. So I have no idea what he plans on saying or why he's there and what he has to offer. But apparently that is the former mayor of the town. Russell Meeks says Jungmin or Jangrin or Youngrin or however you want me to pronounce your name. I'm just not sure. It's borderline Korean. Here in Korea, you pronounce your name Jangmin, but anyway.
What kind of time frame do you think you need to do it? And let me just put out there, I'm not going to get the cart before the horse here, but if as a practical matter, pursuit of discovery is going to deny the evidentiary hearing today, I just would posit, is there any reason that the deposition can't take place today?
Oh, good. That'd be awesome.
Well, I have a 2:30 appointment. Oh! A hearing right here with Judge Bustamante.
Nope.
But ASAP.
Well, that would be as soon as we conclude these proceedings, which might happen by about 11 o'clock.
I would need, Judge, I would need more time.
Okay.
2:30.
I want to be realistic.
Yeah.
But I'm sensitive to time is more of the essence now than it was maybe when we had the discussion on 12/6.
So
Just 'cause I
time
know
is of
months.
the essence. We have to get this
I'm
done. We're going
really-
to push this along
a
as
lot of
quickly as
stuff first half of
possible.
the
I
month
want to
and
do it
pretty much
today.
After the 15th, just nothing but no court appearances. So I can move around the depot to make room for this. So I would say,
Yes.
well, I actually have a status conference with you. Hang on.
Here's the thing, and I know what I just said a minute ago, but you got to take into account, and this is between you and Mr. Hales, to a great extent. Ultimately, the court has to decide if there's a dispute on this, but you should be aware, Mr. Hales should be aware that the delay, whether it's calendaring and other obligations of the discovery, that delay could be predicated upon there being temporary relief of the injunction.
You've already
through the
said
date
this.
you come
You
back.
talked
So
about
I wanna-
this for
I wanna
10
give you
minutes
opportunity to
earlier.
just complete the discovery and then come back for the evidentiary hearing.
That's
You've
what we
already
want to-
talked
Yeah,
about.
right. But I'm saying is, if the deposition took place today and tomorrow we came back for the evidentiary hearing, I'd be less inclined to set aside the temporary injunction because it would be 24 hours long. But if your calendar, and I'm not insensitive to that, causes a delay of the discovery, but the original delay
We
of the
get it,
discovery was
Judge.
on this
Shut up.
precedent, as we already discussed, I still got to consider that if the evidentiary hearing is going to be further out without protection or restrictions in place versus with
Judge,
protections in
You've
place.
talked about it for 10 minutes
that's gonna-
earlier
that's-
or
that's
5
gonna
minutes
be
earlier.
part
It was
of the
probably 5 minutes,
calculus
but it
that
seems
has
like
to
an hour.
Take place.
And we got over
So
1,000 people here
I
and
understand
650
obligations
likes.
of
Thank
other
you guys
courts
for
and
being
other
here and for hitting that
things
like
you've got
button.
calendared, but you have to evaluate, and your client has to evaluate, that the length of time that you're seeking for continuance may be part of the calculus in whether or not the injunctive relief remains.
We know that.
Well, with the last motion, with the new case that came out on the 29th, might have some effect because if in essence, if
I think it might have some effect potentially on modification, but let me say, and I don't want to get too far deep into this. I
Right.
will when we get to it because we
Mhm.
want to keep things in order here because there's a lot. But that opinion from 4 days ago should be of no surprise to anyone in this courtroom because it's no surprise to this court. Because if you go back to the transcript of 12-6 and you read the chief judge's opinion, Sleep from the Second District Court of Appeals from 4 days ago, that written opinion mirrors what this court orally pronounced on December 6th by saying, by the way, has anyone read, hang on, I'll get to it, but
Oh,
it's
the
somebody
case.
versus Harris, Strober versus Harris.
Right.
Has anyone read that? Oh, and by the way, has anyone read the 6 words
Shut
that were added
the
by
fuck
state legislature in October of 21 that may have changed the cyberstalking statute? And by the way,
God damn it! Shut up! I said I wasn't going to do this, but I have reached peak levels of frustration here. We know this guy was an adjunct professor at university. He loves teaching. It's clear he loves teaching. He's not judging. He's not being a judicial officer here. He's being a law professor. He's speculating. Well, they've added this word. Perhaps the word he's being this is what going to a criminal law class sounds like. This is what a law professor sounds like when you're just buried deep in the most boring, frightfully just sleep-inducing class you have. He's being a professor here, not a judge. Judge, be a judge. For the love of God, be a judge. Stop being Mr. Professor and lecture. Well, perhaps it does this. Perhaps it doesn't do that. These 6 words introduced by this isn't put that in an order. Shut up and move on. Put that in an order. Don't just babble on about it now. And before we move on, Jack's mom with the $2 super chat says, your timing is off. That depot hasn't occurred yet. Oh, color me effing surprised. Color me surprised. This time is of the essence and we have to move through discovery as quickly as possible. Deposition hasn't happened yet. And Duncan, Idaho, thank you so much for the $5. Duncan, Idaho. This guy is in love with his ability to really explain. That's what I mean. He's being a professor, not a judge. As long as he's in charge and there's a legal issue to explain, he's happy as a clam. as a law school professor and not a judge would do. Jill Ames with the Aussie $5. Thank you. Judge needs to pull his head out of his bum. It's not a hot. We were cut off. We were cut off by the YouTubes. Oh, my Lord. Thank you, Jill, for that super chat. Jeff hasn't read the 6 words. Jeff doesn't know the 6 words. Yeah, it's the 6 words of power. I haven't read the 6 words of power. I may not know what the 6 words are, but I definitely know that. All right, I won't do that again, I promise. Let's get on to this. Let's find out what the magic 6 words are.
Have anyone taken notice of the fact that there's not been an appellate court decision until 4 days ago?
Right.
And by the way, does anyone read footnote number 1 in the
shut up.
decision that took into account, despite that it was decided on January of 2022, that statutory change may affect the outcome? And so there's no surprise from this court's view, and there should be no surprise from many of the litigants in this courtroom, because what was orally pronounced by this court on December 6th is a mirror image of what was in the written opinion, especially in the concurring opinion of the Chief Justice of the Second DCA, which, by the way, I think also decided the Strober-Harris case. So,
well, that's interesting, but the fact there's 2 separate concurrences, Judge, tells you it's not exact. It is a constitutional issue. There's no blanket. You can't blanketly say.
You're getting me into it. We're going to get
we'll
back,
get into it. Okay,
back
fine.
to this.
Yeah.
What the court says and uses language in the written opinion from 4 days ago about narrowly tailoring the language. If you go back to the transcript of 12-6, and I'll literally tell you in just a few minutes here, I think it was at 55 minutes and 27 seconds through about 58 minutes, and I'll get you the exact meaning of it. This court literally said those words.
You did. And you also said there's been no opinion on, there's been no opinion.
Narrowly tailor it.
Yeah.
So that's not to infringe upon his constitutional rights.
Totally agree.
And I got to say, I read the language for which counsel said no objection. I then took a break. I then wrote it out. I then came back and read it, what I had previously orally pronounced. And again, counsel said no objection. So
what are the 6 words of power?
On Mr. Hale's behalf,
Melon Kurian Abatha Durak
saying
minus
there's no
Mil
reason for you not to
Parad
have
Kabar.
read Bud Love, whatever, the case from 4 days ago, opinion, to now advance a different argument or a more concise, articulated argument based on that ruling. You got every intent to do so. I understand that from your motion. You have every opportunity to do so. We're going to get to that.
Okay. And the way we said that there's no opinion on it. So the way we get that is just go on Lexis and just do a flag if any of the statute ever gets, that's how I got so quickly, I flagged it.
That's what I'm saying. It's no surprise to me.
No, I think the opinion is great. I think it's an amazing clarification. But it tells you how judges, even the 2 up there, have 2 separate basis for ruling.
And to the extent that it's a certification of a conflict with the prior David decision, that's in part of the concurrence of the Chief Justice.
Yeah, which goes back to the old statute. Yeah,
I got you.
Yeah, okay.
I'm there. I was there. I was there 25 days before the opinion was
You know
issued
what?
in my
I
own
don't give a shit.
And the reason
Judge.
because at that point before Bud Love, for this opinion, it seems like it's within the realm of tailoring. It's not a blanket gag order. You didn't order him to take down videos. There's no book burning, digital book burnings going on. It was, but I think this opinion does. We'll get to it, but I think it does really make it clear.
got you.
Okay.
So back to the timing of this. I want you to take into consideration, and with sensitivity to and understanding of other conflicts and calendaring, but it's not going to necessitate or dictate the results of a separately considered issue, which is, does the injunctive relief stay in place? And if so, to what extent, if any, is it modified?
Thank you, Judge. So I would just say, like I said before, we can get these. We have to make sure she doesn't have any, that she's available too. But I really am jammed until Martin Luther King Day. After that, I can move around depots. I'll move heaven and earth to get it done this month, starting from the 16th onward.
All right.
I'll move things.
So I also have to take into consideration, without even you even asking, for instance, I'm not going to have you take the depot and say, okay, we'll see you at 2 hours later or the next day. You might have to digest it and decide, does the deposition require you to go, oh, she named 2 other people I need to talk to or whatever.
And also on that point, that, you know, your point is well taken. We're going to treat pro se litigants the same way as a reasonably competent attorney.
Which you should.
At her depot, she's going to be asked, do you want to read or waive? And if she
Right.
said, so that's going to cause, that could cause 30 days delay. If she says, I want to read my
there's no
transcript.
doubt that if the depot took place on 12/21, which it didn't, we would have been here, I think, ready to go on January 4.
I would.
Even if you had to hustle over what would have otherwise been people's holiday. That being said, it would be the court's intent to give you additional time after the time in which I'm going to compel the depot on a date. I want to get that done
Yeah.
straight. So there's no disagreement.
Okay,
or
all right.
misunderstanding.
All right. We have some clarifications here. First of all, Jill M's says, does anyone else hear the fact sound when the judge, with this judge getting to his point? Yeah, it's just like the internet's not connecting. AOL is not answering his dial-up connection. And Megan Fox, it looks like you have given the same chat. Did you get billed twice for this? No, it looks like, did you get billed twice for this? Looks like you did 2 $10 super chats. I hope that wasn't a double bill. I hope it's just a double post. If it is, we'll work something out. Megan Fox says, is this before the video deposition? I don't think that's happened yet. No. Yeah. Okay. So the timeline I just clarified. This hearing is January 4th. Her deposition was January 16th. So this, I guess her deposition on the 16th is the deposition. She's not being redeposed. Her deposition that we've all watched was on January 16th. This is January 4th. So yeah, that horrific, we'll call it a deposition for lack of a better word, was the deposition responding to this. Right. So yeah, all right. That is now clarified. Timeline clarified. Thank you for raising the question, Megan. You've now locked one more piece of the puzzle into my brain. But we still have to have Septic Boy deposed. We need Septic Boy's deposition. I don't think that's happened yet, has it? Yeah, that deposition was pretty horrific. If you haven't seen it, go back and find it. I did it last Friday, I think, or Thursday, one of the days. I did it last week, and other people have done it. Just go back in my timeline, and you'll find it right real quick. It's a bad deposition. Well, let's continue.
Understanding, clear the decks for the depot to take place, plus fill in the blank days for us to come back for hearing. And I could tell you, I mean, I can cancel things or change things, but I could make that happen. If you're saying, so when you say Martin Luther King Day, some people work on that day, some people don't. The
No,
court observes that as a car holiday.
Yeah.
But that's the 15th. If you can get the depot, you tell me what date subsequent to that, I would offer you
Okay.
Friday, January 26th to return here for the evidentiary hearing.
If we can stipulate now that the transcript doesn't need 30 days for her to read it, we can do that.
If there's a oral motion to advance the time frame in which to review and read,
They're
for
Making an
purposes,
oral tennis right now.
that would be granted. The only question is then to what extent, okay? So
Well, I'll rush the transcript.
depot on what day?
I would like to do the 16th.
So, and again,
And for Cook, probably the next day on the 17th.
Oh shit, I was yelling at the dog and I muted. Well, yeah. Yeah, that's 2 for today. That's a now I got to go back over all that again. All right, I'm confused, and I say sorry for all of you that are like I went down. Right, I say no spoilers because I like things to unfold naturally. But people in chat are saying that the judge ultimately doesn't compel John to give a deposition, which I'm very, very curious about, because earlier on in these proceedings, we had her offer, what was essentially a motion to dismiss the order compelling John to submit to a deposition. The judge says, no, he will be deposed. And as we speak now, they are trying to set a date for John's deposition. He's basically saying that do it the day after we do Tortoise Queen. So I'm wondering at what point and for what reason the judge ultimately says, no, never mind, you don't get to depose John. Let's find out. I'll be interested to see this.
So Cook and Preston, it would be your intent?
Yes.
So Ms. Preston, because you have a right to be present during Mr. Cook's, you've got an obligation to be present for you as the petitioner.
And it could go either way, either orders. It doesn't matter who goes.
Either order, but right. So January 16, 1/6 and 17, 1/7. Can you and will you agree to be present?
Yes.
Yes?
Yes.
All right. So there we
I'm
go.
asking the court not to drop the temporary order. What the court
Then
doesn't
just
realize
wait.
is going
Wait.
on.
To that. You're gonna get to that.
Wait.
I'm going to hear from you on that. I presume you're going to object. So I'm going to give you a chance to be heard on that. But let's get the calendaring of this. Do you know who the court reporter? You're going to issue subpoena to Mr. Cook. You're going to.
Well, he didn't appear. He's under subpoena already.
Right. So it would be continued subpoena to. Let's just go. Who's going to be the 16th? Who's going to be the 17th? Or are they both?
I would like her to go on the 16th.
Ms.
And-
Preston on the
yes.
17th, on the 16th?
On the 16th, and then let's say he can start at. We'll do his at 11 a.m. I don't think I'm going to need all day for him. So 11 a.m. on the 17th. Hers beginning in the morning,
9 a.m.?
9 a.m.
Sir, can we do that at like 10? I have a
That's fine.
special needs daughter.
Okay. If-
I am so sorry, but my child at
Hang on,
8
you don't have to give a
a.m.
reason if
It's
there's an agreement to
It's
it.
fine.
It sounds like there's no objection.
And we're doing it by Zoom, so
Right,
it's not
but
going to
my
be hard.
child.
We don't care.
Medication.
We don't
and
care.
Feeding tube at 8 a.m.
We don't
I need
care.
Time to get her.
We don't effing care. Everybody just agreed to 10 a.m. Shut the fuck up. Stop wasting more time than the judge is wasting. Good Lord. We don't care about your explanation.
Her medications and her stuff
Council
done.
agreed, 10.
10 a.m. by Zoom.
January 16, petitioner's deposition, 10 a.m. via Zoom. Counsel for the respondent, we'll get that all set up for you. You'll get the notice and the hookup for that. Mr. Cook would be considered a continuation of the subpoena already previously served for 12/21 is now extended by order of the court for deposition to be provided to counsel for the respondent at 11 a.m., commencing at 11 a.m.
By Zoom.
January 17 via Zoom as well.
Yeah.
Ms. Preston, you have an obligation to appear on January 16 at 10 a.m. You have
Okay.
the ability to and should be at the depot to commence 11 a.m. the following day of Mr. Cook.
That's fine.
Thank you, Judge.
Okay.
And what was the day you wanted to have the hearing then? Friday, the 26th?
Yes. It's not as
Okay,
much
so
as
if
want.
I can get the transcript rush ordered, and if we can give her, if she wants to read, maybe she can correct it by,
If she-
but see, here's the
she
problem,
can
Judge, you
read.
know, if she changes her testimony by an errata sheet, we have to then inquire as to the basis of that.
We have to cross that bridge if we
Okay,
get to
okay.
it.
So, yeah, I'll
And
get
if-
her.
And if need be, not that I'm inviting this, but if that happens, that may be something that you have to reach out and ask for expedited, hearing, meaning that we're going to come up right in a minute here, we're going to come to a date by which it needs to be read by. If there's an errata sheet or there's some reason for redeposing or whatever, clarifying, whatever needs to happen, we might be able to also still save the January 26th date by this court somehow finding time to address hours, whatever issue
Understood.
might come up. So if we get to that bridge, we'll cross it at that point.
26 works.
The 26th?
Yes.
Ms. Preston, you understand that, and we're going to get to the whether the injunction remains in place through that date, and if so, is it modified or not, and if so, to what extent? January.
All right, before we get to that stage, Tracy Fagan. What's up, Tracy Fagan, with the $2? Feeding tube without running water? WTF? Yeah, it's not a feeding tube. At best, it's some sort of shunt or port for the administration of medicine, if that's even it. I don't believe anything. I really don't. I really don't. But what I do know is we've got some good numbers here. We got 1,005 people here and 700. Oh, we got 1,022 people now and 708 likes. Let's get us up to 1,000 likes. We just need 300 more of you. I know 300 of you haven't done it. Just get out there and smash that like button. And if you haven't subscribed, please do. We are now 13 away from 69,700 subscribers. 69,700 subscribers and just 13 subscribers, which means we are lawyer math 313 away from 70,000. 313 subscribers away from 70,000. That is so cool. I think we can get me to 70,000 by the end of the week. Come on, people, hit that subscribe button. You know you want to. I'm begging for subs. I've been accused of that. Oh, you're annoying. You're the most annoying person on YouTube. You're just begging for likes and subs. Yep.
26, 9 a.m. We're going to come back to.
Because it's cool.
So that I can get my little girl's stuff done.
The problem with that is I don't know how long. I've already made a finding that that
Can
we
we just
needed
do
more
it to
than
9:30?
we needed more than 15 minutes to conclude the proceeding back on
Right.
November 29. I don't know between 15 minutes and
Literally
a whole
DSP.
workday,
I'm
how much time really is needed.
I'm so bad that even
And I don't know
DSP
if
is
you can
critical
answer
of
this
me.
without the deposition first, which is,
Shut up, Brand.
are we going to meet today?
If we
I'm
keep
setting
getting
this up.
new filings, it's going to be new areas of inquiry. That's why it's going to be all day. I
The
believe.
judge is granting a continuance. There's nothing I can
So,
do.
Preston, you'll have
It's not my fault.
22 days, and I'm not insensitive to
It's
your
lagging. The
kids,
judge
but
is
you've
lagging.
got 3 weeks to try to make arrangements.
There is no
26.
babysitters. There's no nothing for my child. I do
You got
not
it.
let John cook. He sits outside with her.
I got you.
We can't because of her illness. We cannot let anyone else
Wait,
near
the former mayor has left the building. He's gone somewhere.
her because a fever can kill her. So we don't do that. It's
So-
fine. I'll just, again, have to
We've got to be here.
try and make
at
it
9
work.
a.m. Because we may be very well faced with the situation like we were on November 29 and not being able to conclude.
Yeah.
And this court's going to do everything it can to avoid that. And quite frankly, it's going to have to be presented on that day and resolved on that day. So 9 a.m., January 26, courtroom 1A, Levy County Courthouse, to conclude these proceedings.
Thanks, Judge. And we're trying to accommodate her. That's why by Zoom, I understand the situation
I got
to the
you.
extent I've heard
Zoom
read the
don't help
proceedings.
when I'm trying to tube feed my child.
Oh,
and
for
give her
God's sake.
meds in her tube. She has a feeding tube, a Mickey button to feed and tube medication in. She sees her medication that has to be taken at 8 and 8.
Okay.
It's,
I've heard, I don't know if you think I
I know,
I'm
it's fine.
stupid.
I got it.
disregarded or disagreed or found what you're saying is
No.
not incredible. I'm accepting that.
I know.
I think council's accepted that. But given that, and despite that, that hour time frame
It's
being
fine.
chopped out of that day on a Friday on the 26th, and what's happened previously in the history of this case, I've got to insist we start at 9 a.m.
Okay.
We got to be ready to go. And quite frankly, although it's editorial comment because it's unnecessary, but nonetheless, if the deposition took place on 12/21, we wouldn't be in this situation. And if it took place on 12/21, I could then push counsel to say, now that you've taken depositions, you tell me reasonably how long it's going to take to try this case. And I can't force that answer because his answer is going to be, I don't know.
I
until
was
take the
not
deposition,
subpoenaed.
and that's understood.
Oh, shut
All
up.
I wanted to
Shut
do
up.
was say goodbye to my mom. That's all.
Again, we haven't, this court hasn't disregarded that.
Okay, now that we know the deposition occurred after this, that sort of clears up the timeline. Mom's going down here. Mom is on her way out, so she's got to go and get get all the things taken care of. She mom's got, mom's on her way out. So she goes down there, and then she comes back for her deposition. 2 weeks later? Well, like 12 days later. She comes back for her deposition, and she's, my mother's dead. Well, then, okay, no, my mom's not dead. So, okay, yeah, all right, now the timeline makes sense. So apparently her mother didn't pass because she said, my mom's dead. Oh, my mom's not dead after this. All right. See, that's one thing I love, and I know I've mentioned it every single time, and I'm going to continue to mention it. There is so much deep lore in this case that jumping into it at the end here, like I'm doing, is so difficult and nearly impossible because there's just so much that I don't know. Does it really? Does the timeline really make sense? Well, it makes more sense. I didn't say it makes sense. I don't believe I said it makes sense. I think I said it makes more sense. If that's what I meant to say anyway. It makes more sense than it did. But you guys are so kind. All of you Hales fans that have been dealing with this for years, that know all of the lore from day one. Thank you for educating me step by step as we go along. The comments you leave on the videos after, the chats that you put here in during the live streams, it gives me this more and more information as we go along, and it's like the Rubik's Cube. Things are starting to click into place. So a little more every day, we put another piece in the puzzle, and all the other metaphors I can think of. So seriously, thank you for your kindness and your generosity, bringing all of us, not just me, but everybody else in LawTube up to speed, and everybody else that's following it, because it is hard for us to get our minds and brains around all of the facts and ins and outs of something that's been going on years longer than we've been paying attention to it. So thank you so much again for your kindness and your understanding. Appreciate it.
Accepted that, and I don't think council has. But it's created a situation that we now are trying to remedy.
Rich, which also one he did created.
Which is creating some pressures. So the one piece about Depo 16th and 17th transcript to be provided and read by in anticipation of the January 26th.
Hello, Yellow Flash. We have a flash sighting. Are you here, Yellow Flash? If you are, hey,
so
good to see you, brother.
Preston, basically, there's going to be a process at the end of the deposition. You're going to be told that you have an opportunity, if you wish, it's up to the deponent, to read the transcript, or you can waive doing so. If you say
hey,
no,
Flash, yeah, Tug was on here last week.
Council is suggesting, and it seems pretty reasonable.
And Megan Fox is here. We're all here. Good to see you, Yeller. Sorry I missed last Sunday. I was hungover.
So by that date.
Badly.
And can you do so?
That's fine.
All right.
So you'll have a week.
Can we apply the same standard to Mr. Cook's deposition?
Mr. Cook's depo of the 17th, likewise, since you're a party present at the deposition of Mr. Cook, likewise, you could review that. She can't really do an errata sheet for that, but you'll have a chance to review it, but likewise, the same time frame by
It's fine.
January, and to be specific, by January 23rd, 5 p.m.
Thank you, Judge.
Can someone shut up, old man, please? Hey, Jonathan, you better be talking about the judge and not me.
So knowing
better
the
be talking
precedent
about the
against are
judge.
held to the same standard, the
Right.
court, you have discretion. It doesn't say shall, but this delay created expense, created attorney's fees. I understand what's going on here, but I'm here to request fees
There you go. Good.
based on the violation of not showing up, not setting a protective order, and creating the delay, granting the motion to compel discovery, and granting entitlement to fees. And while I'm on that point, respectfully, Judge, even-handed justice here. We want the same parties, the same scales. The right hands and the left hand should act equally. So this requirement in this case for the parties to prove the basis for requesting continuances was held here. I asked that she produce proof of this doctor's appointment. When was it made? Was it made? When was it canceled? Did she really have to go out of town? Just proof.
Yes,
Right.
I
And
do. and I provided
an email
proof
from her
to the court.
sister is not proof.
Then I'll get it.
Oh, see, we're on. I'm a prophet. I'm on the same page. A letter from your sister saying what day you got there and what day you left is not proof your mother's dying. She's on life support. She had to go there. He's like, and stop interrupting, by the way, you dumb cowbag.
The hospital was supposed to send me something, And she didn't send it to me.
Oh,
but I'm
yeah, the
okay with
hospital,
her
they
today
never
and
send you
get
the
that
documents, do they?
immediately.
So let me say, under appropriate circumstances, under the rules of procedure, rules of civil procedure, counsel, under certain circumstances, can, on behalf of their client, seek compensation for fees and or costs expended for depositions that didn't take place. Now, there's a bunch of requirements.
It's like you're a
to
lawyer or
establish.
something. I know,
Given
right,
that there's
Tammy?
such a request,
I'm not as dumb as I look.
and given that there appears to be, based on your representations, your ability to establish why you were not where you were supposed to be, kind of thing. And clearly that's relevant to this court's consideration of whether to impose those costs and or fees. I'm going to take the request for fees for non-appearance at the 12/21 deposition under advisement. I'm going to reserve ruling on that, but it's going to be subject to directing Ms. Preston for you to provide by
Real proof.
January 23rd,
Okay, so that should have been provided already.
and or whatever form of corroboration you have that you had a medical appointment. It does not have to disclose what would otherwise be protected medical information, but a doctor's office confirming that, yes,
I had an
Preston
appointment and I had
And
to
that-
cancel
yeah,
it.
shut up.
on this
What?
day at that time.
Right, and I had to cancel it that day too, to go to Naples to my mom.
And
But they will
maybe,
say that.
again, some documentation that she was hospitalized. And
Yep.
Okay.
Thank you,
Got it.
Judge, for being at least
Filled up with gas in Naples.
a little
come
fair.
back, or whatever you have that you think is form of corroboration. And what counsel is saying,
I will get
I
something from the
found
patient liaison.
incomplete at best compliance or non-compliance, I think is what I said on December 6th, about the whole issue with Mr. Hales going to Ohio. You've raised that in one of your affidavits that I'm not adjudicating. Also, same requirement, you got to provide corroboration to explain why you did or did not have the ability to attend the depot on
Yep.
12/21. That will in part help determine whether or not
You
fees and
pay.
costs are assessed for the non-appearance of the depot.
Yeah, and see, here's the thing though. Let's say she doesn't provide the proof. What are the chances the judge is actually going to award fees to Jeremy Hales? Let's assume he does say, okay, you owe your lawyer for the time, which, you know, the way this judge is rambling on, is hours and hours and hours. I have no idea what he's billing. Let's be very, very conservative and say he's billing $500 an hour for 8 hours. Yeah. Let's say he says, okay, you owe him $4,000. Let's say he owes him $4,000 in legal fees. Just to say the judge in some, random fit of lucidity awards him $4,000 in legal fees payable by her. How is she going to pay that? With what money? See, that's the thing. It's the old blood from a turnip thing. You can't get blood from a turnip. Some people are just judgment proof. They got so little of anything that you can't get anything out of them. You can win an award for $100 bajillion. And if they ain't got nothing, you ain't getting nothing.
Right. Plus the fact that I called the clerk of court the minute he called me, the minute.
I've got you. Okay.
So
So counsel, to the extent that
Okay, thank you, Judge.
that covers it, the oral pronouncement of this court is the ruling and it is reflected in this record. Chronologically, just to complete the matters that are otherwise been filed up and through this date, the next matter, which has already been resolved by order of the court, was respondent's motion to disqualify, filed Thursday, 12/21 at 6 p.m., which is effectively Friday, 12/22, which is, as a matter of course, the day before a 3-day court closure because of the holiday, previously of record as a court closure. The court ruled, as the rule requires, 2.330 on 12/26/23, order denying. So that matter has been adjudicated and resolved. The next matter chronologically is styled as petitioner's petition by affidavit for violation of injunction, filed 12/29/23. That matter, as I mentioned with regards to other similar matters, The affidavit for alleged violation under Florida statute 784-0487 is currently under the purview and obligation of the Office of the State Attorney to review and determine how to proceed. So there's no need for court judicial labor at this point on that matter. There may be in some later date. The next numbered issue is, or I guess filing was respondents' notice of supplemental authority, which is a motion to modify the extended temporary injunction and a request for judicial notice of case precedent involving a ruling previously commented upon by this court and by counsel, issued 12/29/23 by the Second District Court of Appeals. We're going to address that here in a minute because of the continuance of the evidentiary portion of this matter to January 26th. But let me address two other matters just for this record so it's complete. The remaining two matters that were filings between setting this hearing and this hearing date today included petitioner's additional affidavit alleging a violation of injunction filed 1/2/24, again pursuant to statute 784-0487. That's within the state attorney's purview at this point. Subsequent to that, January 3rd, 2024, petitioner's affidavit for alleged violation.
Oh my God! So like she's filing these motions for alleged violations of these restraining orders every day. She's just filing one after another. Gonna bury this poor lawyer under a bunch of basically complaints to the bar.
Again, is within the state attorney's.
Oh, these are three different motions she's made.
784-0487. I believe that addresses all matters that were filings. I hesitate to say, but it's worth saying that between now and January 26th, if there are additional filings, it would be the court's hope that none of them are designed to delay the resolution of this matter on January 26th, and that we could otherwise have this matter resolved. With regards to any affidavits for violation, the protocol, 30-day time frame for the state to review. There's also a potential 20 days for law enforcement to review those kinds of allegations. Those are going to follow their own time frame and path. With regards to this court's intent to resolve the evidentiary matters before the court to be adjudicated on or about January 26th, that should occur. So what that leaves us with, let me get to it a second, is what respondents counsel filed, which is on 12/29/23 at 4:24 p.m. What's entitled Notice of Supplemental Authority, that authority being the Budlove decision, which is cited at 49 Florida Law Weekly D50A, a second DCA opinion.
All right, that sounds really thrilling. So we will pick this up tomorrow. Let me make a note of the timestamp here. We've done a good solid 2 hours today, and we'll do a good solid 2 hours tomorrow to get through this hearing number 3. What the hell they're going to talk about for the rest of the time is completely beyond me, but I guess we'll just have to wait and see until tomorrow. People, look, I think, I mean, it would go over like a pregnant high jumper, but Jeremy should submit about 2/3 of his legal fees to the judge. I mean, at least 2/3, and say, look, if you would have just been a judge and not a law professor, and gotten to the point and stopped repeating yourself and stopped pontificating and stopped lecturing and stopped teaching and got to the damn point, my fees would have been 1/3 at most of what they are now. I mean, I just, as lawyers, I sit here and I'm just watching. She's got nothing to lose by sitting there at the table, being obnoxious. She's got nothing to lose by filing motion, stupid motion after stupid motion after stupid motion. Every one of these things has to be addressed by his lawyer. His lawyer's got to be here in court with him. His lawyer's got to do his own work outside of the office. I just see the dollar signs rolling while all this is dragging on and on and on. I said I wasn't going to get upset and to go on these rants today. I did pretty good. We had a few rants, but but it wasn't as rant filled as because I'm kind of getting into the area of disgust and just tiredness now. I'm just tired with the judge. I'm tired. I'm tired of the judge. I'm just disappointed and disgusted by a lot of what he does. He has these moments of lucidity where he makes decent decisions, decent rulings, where you can see he's getting short with her. He's losing his patience. He's trying to talk as nicely as possible to her. But still, we've heard from Jeremy's lawyer a grand total of about a minute out of an hour and 10 minutes of proceedings. And of course, he's got to go back and bitch and moan about the things that we're done. November of last year, the going to Ohio thing, the rescheduling of the hearing. He's got to go back and harp on that. He's got to bring that up and point more fingers at Hales, which just doesn't need to be done. Well, we'll get through the second half of this tomorrow. You got to do this in small doses. It just wears you down. It just beats you to death. But I'm very, very happy with getting involved in this and getting to know more and more about it. And as I said, reading all of your comments and things to clarify the lore, to tell me who the players are and what the hell is going on, because it doesn't make a lot of sense a lot of the time. I'm going to look for somewhere here to send you all off to. Who are we going to send you to? Let's see. YouTube Studio. Let's go to YouTube Studio. Content. Oh, hey, we're 6 away from hitting that 69,700 mark. Everybody get down there and smash that subscribe button. It doesn't cost anything, and you can just hit it and forget about it. Never visit me again, but I hope you'll hit that subscribe button and come back and visit me every single day at the same time as we talk about lots and lots of neat things. All right, let's see here. Where are we gonna send you? Where should we send you? Go to customization. Go to redirect. There's lots of things going on, and I can't decide who to send you to. So I'm gonna pull a judge here. I'm gonna say I've just wasted the last 2 minutes of your life, and I'm gonna send you off into the great white, where you guys can go figure out where you want to go. Go wherever the wind takes you, or go to your favorite channel that's streaming right now. We'll just send you off into the wild. Really quick here as we run this up. This is your last chance to make me happy, to hit that like button, hit the subscribe button. Our poll for today, our like and subscribe poll was, how would you market the tortoise preserve? If you could make a sign to market the tortoise preserve, what would the sign say? 7% of you said tortoise rescue. 8% of you said tortoise rescue. 31% said tortoise woman, please beware. And a full 54% of you, more than half of you, said don't feed the tortoise woman. Okay, there we go. That's our like and subscribe poll today. That was the best I could come up with in all of my creative glory and genius. Audio Coffee says, thank you, Legal Vices. Tomorrow was a fun trip for you. Won't be here fixing computers. No, don't send Lienette to me. I'd fix her. Oh, no, I'm sorry. I read the last part of that. But tomorrow we'll do part 2. Wednesday, we might look at some of the evidence she submitted in her 338-page submission. Thursday, we're going to be covering the final bits of the closing arguments for the O.J. Simpson trial. We've been covering the O.J. Simpson trial basically every Thursday for nearly a year and a half now. And then we're going to move on to another trial. I just do retro trials on Thursday. The next trial we're going to hear is an elderly gentleman who deleted his entire family in what the prosecution calls a ritualistic witchcraft murder. So we'll announce that when it happens. Then Friday is F It Friday, where we say F it. We have a great panel of guests lined up. And once more into the breach, let me remind you of who is on the guest panel so far. So far, the guest panel is, where are we? Where is the guest panel? Aha. It is Danny on direct, potentially criminal Sean, that Star Wars girl, Nicholas Starro, comedian Lila Hart, lawyer extraordinaire Ian Runkle from Runkle of the Bailey, our very own Flux, Aussie Overlord will be there, Lady Law 579, social media influencer Lauren De Laguna will be there, and again the origin of the cow bag saying, the follower of the royals and all things English. That would be Steph, the Alter Nerd, will be joining us. Still waiting to hear back from Megan Fox. She said that she will try to be there, so I will call that a yes. Even if she pops in for a few minutes, she should pop in. And MG Law said he would be there too. So MG Law, those are some of the people that are going to be on the panel. It's a griftathon. I grift for money, do shots in exchange for every $100 that comes in. It's a once a month fun fest. We'll be doing Irish whiskey because it is St. Patrick's Day weekend. We'll be doing Bushmills 10 and a Redbreast 12 Scotch until you run out of money or I run out of liver. So, all right. Thank you, mods, for being here. Thanks for everything you do. I'm so glad you're here. We'll see y'all tomorrow. Thank you so much, chat, for the super chats, the memberships, everything, and just for being here in chat, keeping me company, keeping each other company, keeping it real, informing me as we go along. I'll see you all tomorrow. Same bat time, same bat channel. Until then, enjoy your day or your night or evening. It's me, Lawrex, saying thanks and peace out.